One of the first answers is that I was not very happy with the current accounts that we have of the authority of international law in our own discipline, in public international law. We usually tend to think that international law's authority comes from its binding qualities, so we just repeat almost as a mantra that international law has authority when it's binding. This is a very thin and not a very well-developed account of the authority of international law. As I was quite unsatisfied with it, I thought that we needed a better account, a more robust account of the understanding of the authority. The second reason has to do with a very loud choir of critiques of the authority of international law. I thought that not only we didn't have a very robust account, but also that we were unable to defend ourselves against the critiques of this account. Imagine, from these very loud critiques coming from the realist international relations school to the rational choice theorists to democratic legitimacy critiques. So I think we need an account that is more doctrinally defensible, as well as defensible against external, extra-disciplinary critiques of the authority. Now, of course, I would love to say that I'm going to change the world with the book, but I don't think it's going to happen. But one of the things I think the book tries to achieve is giving a more doctrinal and a practice-based understanding of how the authority of international law should operate in domestic legal and political systems. So when I was writing the book, I had in mind a judge, perhaps sitting in Ankara, and somebody, throws him a little international treaty and says, here's an argument from international law, and if that treaty is conflicting with the domestic law obligations of that judge, I just want to be the person that would help that judge in order to understand and then to reflectively assess the authority of international law that he's confronted with. Conceptually, what I'm trying to do in the book is to say that we have to move away from some of the standard assumptions about authority when we talk about it in the international legal sphere. Authority is not an either-or concept. You could have different types of authority relationships. In the book I call these strong, weak and rebuttable authority relationships. Authority is also not something that you can automatically apply, that there is a space for reflection as well as assessment of the authority competitions, and the book tries to contribute to these very difficult questions, but I hope that it is doctrinally and practically interesting and important for the decision maker.